Welcome to this week's edition of It's Chaile Time. This week I am sitting here at the Daily Coffee, a wonderful coffee shop here in Ferry Glen, Victoria, and we'll be looking at constructive dismissal, what it is and what the test for intolerability is. It's probably one of the most prevalent forms of dismissal disputes at the CCMA, but also one of the most difficult form of dismissal disputes actually to succeed in. First of all, the onus or the burden to prove that a constructive dismissal actually exists rests on the employee. As you know, with normal or other forms of dismissal disputes, the onus to prove normally rests with the employer. But in constructive dismissal, the onus to prove that the employment conditions was intolerable and that you were actually constructively dismissed rests with the employee. So we'll be looking at Brown's The Diamond Store versus Belinda Michelle Du Bois, and this case was ruled on by the Labour Court here in Johannesburg, June 2023. So this is a very recent case law that came out. A lot of employees feel that the way they are treated at work normally renders a employment relationship intolerable. For instance, you have a manager or a business owner that is a very hard person maybe, or they swear a lot, or maybe, they don't operate the work environment in a logical and a consistent and, in your view, a fair manner. So often employees will consult us and say, but listen, the workplace has become intolerable. Why? Because my manager is swearing at me a lot, or they keep on changing my shift, or it may happen that they're not always paying you for the overtime that is due. So when does a constructive dismissal really exist? Okay, so but in this case now, this employee was employed in March 2009 as a sales consultant at the Airside store in OR Tambo International Airport, and she resigned from her work on the 25th of October 2020. So she's been at this company for probably for about 11 years, which is quite a lengthy period of time. Now, the whole instance of her resigning actually stemmed from the fact that in April 2020, she actually approached her employer to ask for a voluntary retrenchment. I've seen that in some instances whereby an employee will actually approach the employer and say, listen, can you please retrench me? Now, normally, I can only be presumptuous in this case that she must have thought, that if you are retrenched with a severance package of 11 years, there may be a handsome fee involved here, from a package perspective that is, and maybe she had the intention to start her own business or whatever the case may be. I'm not saying that is the case here, I'm just saying that normally that can be the line of thinking of somebody who's asking for a voluntary retrenchment. Anyway, the employer in this case felt that, and actually explained to her that she's actually a valuable person of the company, employee of the company. She's a good sales consultant, and she's the kind of person that would like her to be retained. And so forth, they rejected her application for a voluntary severance package. Interesting is, from that point, she was aggrieved. She never formally raised any grievances, but she was aggrieved and started a line of communication that was malicious towards her employer, for which she eventually received a warning for insolence. She was disciplined for insolent and rude and insubordinate behavior. This didn't stop though, and she continued with a line of messages and communication to the employer. Now, I just want to read some of these messages. It's quite disturbing, if I can put it this way, and I can't believe that somebody will have the audacity to write messages and communication like this to your employer. Okay, is this because I have dared to question the impotence of Larry Brown, who continues to lack the courage to speak to me? Watch this next one. Your nonsense will no longer be tolerated. This is she writing out to her boss, né? I have been and have tried at all times to be civil and courteous. This despite the superfuge and lies I have been subjected to. At least one of the company shops in London is engaging in false advertising, and was and still is the case here. I shall be making complaint against yourself and the company to the Jewish Board of Deputies. At least I shall expect your apologies and feel that the Jewish community in general should be made aware of your contempt towards them. Oh, look at this one. I am disgusted at Larry Brown's lack of response to my greetings sent to him in good faith for Yom Kippur. He may well be a soulless individual, so it seems, but he should be aware that manners maketh the man. Then she continued by saying, I expect an apology from Mr. Brown. As the person who makes all the decisions in the company, his behavior to me is disgusting and inexcusable. Then she continued to say that perhaps he holds Jews in the same disdain as he appears to hold certain other groups. Then she went on to rave, perhaps I should discuss this with the EFF Central Command and have them come along and demonstrate at the shops on my behalf. Actually, that's a very good idea, now that I think about it, especially as Larry Brown wants to ignore me and will not meet with me. Arrogance and cowardice come to mind. So she went on this whole list of further communication in this regard. So naturally, the employer at that stage felt that they wanted to take her to a disciplinary action or to a disciplinary inquiry, and they booked her for a disciplinary hearing. But very interesting is, then she immediately rendered a doctor's note booking her off for the next 2 months. So that was from the 13th of September. For a period of the next 2 months, she had now been booked off ill from work. So they could obviously not commence with a disciplinary inquiry at that stage. During this time, while she was on sick leave, the employer then invited all the staff to a staff meeting regarding the opening of the store, and naturally she was not invited, and there was also then a roster worked out for when staff will work, and she was not placed on the roster. The employer's view was she could not be placed on the roster because she was on sick leave. So the employee on the 25th of October that year, 2020, resigned from her employment. Now, this matter went through the CCMA. She actually won the CCMA case, and in that instance the commissioner found it's quite silly actually, and the Labour Court also noted this issue, that most of the decision that impacted the commissioner in terms of whether the employee was successful in this claim was based on a restraint of trade. It actually had nothing to do with the case whatsoever. So by implication, to me, it seems like maybe the employee wanted to resign to open a job or her own business and was probably in competition with the employer. So the restraint of trade issue became an issue at the CCMA, but it was never part of this main line of dispute at all. The Labour Court judge actually found that she actually misconstrued the nature of the inquiry. The restraint of trade was a contractual issue and had nothing to do with the main dispute at all. So anyway, that influenced, or mainly influenced, the Commission's decision in awarding in favour of the employee. But anyway, the Labour Court again reiterated that in order for a constructive dismissal claim to succeed, 3 elements must exist. And you must listen carefully now. For every employee who wants to file a constructive dismissal case at the CCMA, there are 3 elements that must be true. Number 1, the employee must have resigned. If you didn't resign, there's no constructive dismissal case. Number 2, the employment conditions must have become intolerable. If it's not intolerable, and note this word, not a mere inconvenience, it must be intolerable. If it's not intolerable, there's no constructive dismissal. And thirdly, the employer must be the responsible party who created the intolerable work conditions. Nobody else but the employer. So the Labour Court continued by saying that notably, if one of the above requirements is absent, those 3 I've just mentioned, a claim for constructive dismissal must fail. By way of an example, there is no constructive dismissal if an employee terminates the contract of employment without the 2 other requirements present. There is also no constructive dismissal if the employee terminates the contract of employment because he cannot stand working in a particular workplace or for a certain company, and that is not due to any conduct on the part of the employer. The Labour Court continued. In National Health Laboratory Services vs. Iona and others, the Labour Appeal Court defined the test for proving a constructive dismissal as an objective one. In essence, the conduct of the employer towards the employee and the cumulative impact thereof must be such that, viewed objectively, the employee could not reasonably be expected to cope with it. resignation must have been a reasonable step for the employee to continue to take in the circumstances. So it must be the reasonable conclusion or result that based on the intolerable conditions that resignation is a reasonable outcome of how to exit this intolerability. So what are the tests for intolerability? First of all, we've just seen now it's an objective test. It is not a subjective test. So it is not based on necessarily how you feel. Humans feel different things, you know. In the one company, you know, you can find that an employer maybe is rude and the staff are fine with it. I've seen in some other companies, you know, where a manager will just do the smallest thing and suddenly, you know, the employment relationship is intolerable. You know, so you can't rely on emotion or subjectiveness. It must be an objective test. There's a bit of a test here in terms of how the courts, and this is also supported by the Constitutional Court, how they view intolerability. In Gold One Limited versus Madelani and others, the court sanctioned a well-established principle that intolerability is a high threshold, far more than just a difficult, unpleasant, or stressful working environment or employment conditions, or for that matter, an obnoxious, rude, and uncompromising superior who might treat employees badly. Put otherwise, intolerability entails an unendurable or agonizing circumstance marked by the conduct of the employer that must have brought the employee's tolerance to a breaking point. So there you have it. Intolerability is not a mere inconvenience. It is not just the fact that they paid you a day late. It's not just the fact that they gave you a warning or maybe gave you 2 or 3 warnings. It's not the fact that the senior may be rude or maybe swearing at you. There is another case, for instance, that deals with the issue of employer swearing at staff, where the judge actually said that the workplace is not a heavenly garden filled with smiling Buddhas, and that employers and managers are also subjected to stress like everyone else are, you know. So if you're going to think that you're going to resign just because you've got a rude boss and think you're going to win a constructive dismissal case, you will probably not. You have to show that the workplace really became intolerable. It's an objective test. It was created by the employer. And probably, you know, what will go a long way in being successful with a claim like this is that you try anything to remedy the situation. Like, for instance, that you submit a grievance to resolve the matter. What did you do to try to resolve the issue? And there are some other cases at the CCMA you can also file suit on to try to remedy a situation. If it's a discrimination matter, you can file an unfair discrimination claim. If it is unfair discipline, you can file an unfair labour practice claim in terms of Section 186, subsection 2 of the Labour Relations Act. So what have you done to try to remedy the situation? In this case, she never filed a formal grievance. Actually, it's quite clear, you know, she resigned to avoid a dismissal because of her rude and insubordinate behavior. So yeah, there you have it. Constructive dismissal. The onus is on the employee to prove. It's quite difficult because a lot of employees misunderstand this notion that just because work life is difficult or inconvenience, now if I resign, now I'm going to file a constructive dismissal case. Not so easy. But anyway, that is all for this week, and see you next week, and don't forget to like and subscribe. Thank you.